How do you propose we deal with the issue of recusal? Because it seems to be foremost in these proceedings. If we proceed with objections without the issue of recusal having been settled, where is that going to leave us?
I would imagine, I nearly said my lady, I would imagine, Chairperson, that the people who have prepared that application, I think it is Mr. Gwala, would be able to move that application, who are not ready to move such an application. I do not believe for the moment, given what you had what your ruling earlier on, which is what we, if you look at our notice of objection, we had indicated that we abide by your ruling, the ruling that said that for purposes of the issues that Semenya may or may not have been conflicted, another evidence leader will lead those witnesses. We have indicated, we've stated in our objection that we abide that ruling. So we do not have, for the moment, any application before you, because I'm made to believe your response was that a substantive application must be brought. We haven't brought that application. We abide your ruling, which indicated that somebody else amongst the team would lead the evidence where you are of the view that it may raise issues about conflict. That's where we are.
Is it not blowing hot and cold? You're not taking a stand. Should you not take a stand and say, well, we have to deal with the objection because the argument is that if the objection is upheld, the entire proceedings would be tainted.
That's not what our objection says, Commissioner Hum, at all. That's not what we say. What we say, I'm not sure whether you want me to go to my objection, but what our objection says, it says, we learned at the second hearing that Mr. Semenya had made a private arrangement that we were not privy to about the leading of 8 witnesses by Mr. Vani. We object to that because 1, we were not told, 2, we were not given an invitation to comment on that arrangement. 3, the chairperson herself had already made an order as to how witnesses are going to be led. That is our objection. It's a process and nothing else.
Yes.
We then gave an indication that it may be that we're going to move an application for recusal. So we're not blowing hot and cold. We're very clear. Our objection indicates what we want, and the submissions take that objection further.
Yes.
And if I might be allowed for a moment, we are agreeing with Mr. Vani that it is the decision of the commission that must be upheld. That's decision in terms of Rule 3.1 that says the commission is empowered or obligated to make decisions about who calls who when, and not Mr. Semenya. And that therein lies our objection. We're saying he took the matter further than what you had indicated. He says it's a different issue about conflict and whether he can have a private arrangement with Mr. Vani. We say the rules are clear. On the direction of the commission, you can lead your evidence under your direction. And that's all we're saying.
Yes. Ms. Moroka, I have this particular difficulty. In your submission, you say that you intend to bring an application for Advocate Semenya's recusal in due course. In due course. That's what you say. And my difficulty is, how do we start with these proceedings when the issue of Mr. Semenya's recusal is still hanging and has not been decided upon?
Madam Commissioner.
If we start the proceedings, we make a ruling with regard to the objections, we proceed to the leading of witnesses, the issue of Mr. Semenya's recusal is then brought in midstream, the leading of witnesses, where does it leave the commission?
Our submission would be the witnesses that are going to be led are not going to be led by Mr. Semenya, according to your rule. So for the moment, Mr. Semenya, as far as we are concerned, is not in play, as it were, because he will not be leading the witnesses. You have made a ruling about the leading of those witnesses. And I'm assuming those are the witnesses that are going to be called first. Mr. Semenya will not be leading those witnesses.
Ala?
Thank you, Commissioner, and members of the Commission. I hope I'm audible.
Yes.
I understand what the Chairperson wants us to deal with now relates to the appropriateness of Advocate Semenya sitting as an evidence witness, not yet the part where we talk about the determination or the
If you can just speak up a bit louder, we can't hear you.
I think, can I use this mic? Was very audible, and
Yes, we can now hear you.
I could hear that I was not audible. What I'm saying, Chairperson, I understand that you are directing us at the moment to deal with the question whether, or the objection, whether Mr. Advocate Semenya should sit as evidence leader at all.
Yes.
That is, whether he is conflicted. Our issue, as instructed by those who are instructing us, the NPA, whom we represent, is that once upon a time, Advocate Semenya SC advised the NPA on the prosecution policy, which we all now know that it was set aside on the ground that it was unconstitutional. The NPA is unsettled by the fact that that very policy is the policy that is said to have brought about the interference, the so-called interference in the prosecution of the apartheid crimes. That policy is central to these proceedings. Now, you've got our colleague Advocate Semenya having advised on that policy and having given opinions on that policy. It then appears to us as the NPA that it is inappropriate that he should sit in the proceedings. We understand the letter that was written by, I'll call them the Galata family, where they were objecting, but their objection was to the fact that he represented the NPA in the Katimeng matter. And the answer was that the court in those proceedings was not necessarily dealing with the question whether or not there was an interference. Perhaps one at that level can accept that that answer may suffice, but ours goes further than that. Ours goes so far as saying, you actually played a role in advising us on this policy. Which policy, to a greater detail or to a greater extent, is the reason we are here today. So you could not advise on the policy itself, and having advised on the policy and come and sit when the policy is scrutinized. You'll find you end up in a situation where you are either defending the policy or you are, perhaps not defending the policy, but we are saying it is inappropriate that he should sit as evidence leader on those grounds. If I may summarize, Chairperson and members of the Commission, we are simply saying, because Advocate Semenya SC advised the NPA, gave opinions, even to the extent of representing the NPA, then on those bases he should be disqualified.
Yes. My question is, shouldn't you bring a recusal application in that regard?
Substantively.
A substantive application to recusing instead of raising it as an objection, as you have done.
Well, perhaps that is the other way of doing it.
Isn't it the proper way of doing it?
Well, in the meeting that we had, it was said the objections must be filed. Perhaps it could be that we need to bring a formal application. I'm not taking it, I'm not against that, but this is how we have done it. If needs be, we will ask that we be allowed an opportunity then to bring that application.
And if you are given that opportunity, when will you be able to bring such an application?
The Commission can set out time frames for us. We are here. We've been reserved for this process. So
yes.
the Commission can set out time frames for us to bring that application.
Yes.
Advocate Gwala, you foreshadowed this in your submissions.
Yes.
I think in paragraph 14.3.
Yes.
Where you said that this ought to be determined on affidavit. So I think, so if I understand you correctly, what you're saying is that you want directions from the
Yes.
the chair.
Yes, the Commission to give us direction, including by when the affidavit should be filed.
Yes.
Yes, because you see, procedurally, otherwise it would make no sense who argues the issue of recusal. Does even now, does Mr. Semenya argue? Because if it's an objection, does it relate also to him now coming to justify his own position?
Certainly it does relate to him with due respect, but Commissioner, I accept that it will be of good order to do it, to come by way of a formal application.
Yes. Okay. Ms. Moroka?
If it be the decision of the Commission that we had undertaken that it will be a substantive application as per your order, we are prepared to abide by the time frames that you set out.
Yes. Yes. We'll take a short adjournment to consider the directives. Yes. Yes. With regard to this issue, can we hear any other party who may wish to add on what has been said by Advocate Moroka and Advocate Gwala? Mr. Van?
As a chairperson pleases, chairperson on behalf of the Kalata Group of Families and Foundation for Human Rights, we were the parties that brought the issue of Mr. Semenya's situation to the attention of the Commission. The Commission responded and indicated that another evidence leader would deal with the deliberations around the prosecution policy amendments, and we have indicated our satisfaction with the Commission ruling in that regard. We accordingly abide by that ruling.
Thank you. Any other party?
Thank you very much. I appear for Advocate Sean Abrams.
You said your name was?
Mpati Kofa Lebakeng.
Kofa.
Yes, Chairperson. As far as the issue of Advocate Semenya's recusal is concerned, we have not taken instructions. Yes, we have noted the issues raised by both Advocate Gwala and the Minister for Constitutional Development. But we would like to place on record that we will take full instruction on the issue and will be able to provide and follow the timelines that are provided. Thank you.
Thank you, Ms. Kofa.
Thank you.
The commission will take a short adjournment. We'll reconvene in 10 minutes.
Red light is on. Yeah. Is on. If you hear yourself through the speakers, then you should. Yeah.
Okay.
Okay. I'll just get them to tape it on your.
So is it currently on or off?
Yeah, it's on.
Okay.
Are we not going to speak, sir? I think that's
I fear this is going to fall off.
I'm also afraid of it.
Can we do it like that? Rather?
Yeah. Do that, I fear my job.
So, testing.
We'll just bump it up. If you can't hear yourself on the speakers,
Okay.
this thing is off. I'll push it up.
For the moment, should I turn it off?
We issue the following directions with regard to the application for the recusal of Advocate Semenya. It is directed that the National Prosecuting Authority and the Department of Justice are to file their founding papers in the application for recusal by Wednesday, the 12th of November, and answer thereto by Monday, the 18th of November, a reply, if any, by Thursday, the 20th of November. Written argument is to be filed by the parties by Monday, the 24th of November, and oral argument is to be heard on Wednesday, the 26th of November, 2025. Thank you. The proceedings are adjourned.